really the part of the point of doing this webinar is that we're hoping that some people are on the call will want to put in a response to the discussion paper, respond to the consultation. If you're really only interested in certain parts of the paper, or your expertise or your interest relates to certain parts of the paper, please feel free to put in a response that only deals with questions in connection with that part. I know that the discussion paper is quite long, and of course we do love it when we get, responses in from people that write the full exam and answer all the questions. I completely appreciate that that's not possible for everybody. So if you only want to answer a few questions or one or two questions, we will be just as happy to get responses along those lines as we are to get comprehensive responses. So don't feel that you need to answer every question. It's just to make that clear from the beginning. Okay, so what I'm going to do is just give you a sort of reasonably high-level overview of what is contained within this discussion paper. Let me start by just setting out how or why we came to be doing this project on owners associations in the first place. As some of you will know, the genesis for all of this is the fact that over several years, the Scottish Government's research into the condition of housing in Scotland showed that the tenement stock was in decline. So that the tenement stock is not in a good state of repair and is also in a declining state of repair as the years pass. Now, it was recognised in Parliament and government and so on that there are particular challenges to trying to improve the condition of tenement stock that maybe don't exist for other types of housing. So some of those are technical barriers to do with the way tenements are constructed. Some of those are obviously legal barriers that surround the requirement for various people to coordinate before works can be carried out. And there's maybe other kind of behavioural, cultural factors too. So in recognition of those difficulties, a Scottish Parliament working group was convened in connection with tenement maintenance. So that was a group made up by some MSPs from different parties, but also of people or organisations with expertise in connection with tenement maintenance. So whether that was architects, surveyors, people with expertise in the fabric of buildings, or property managers, local authority housing officials, just a kind of quite a wide group of people with interests in the area. So the working group in 2019 came up with a set of recommendations for things they thought needed to change in legislation or in practice to make improving tenements easier to achieve, essentially. So to try to deal with the condition of the tenement stock. And one of the recommendations they put forward was the introduction of compulsory owners associations for tenement buildings. So these aren't the kind of informal owners associations that do exist in some tenements at the moment, where it's all sort of just kind of quite informal and one owner kind of has to act really on behalf of other owners in terms of maybe opening a bank account and things like that. What the working group had in mind was a new form of legal entity, which is an owners association, which has legal personality in the same way that a company or a limited liability partnership has legal personality. So you would have an owners association which has legal personality, a sort of a person in its own right, and the owners of flats in the building would be the members of that owners association. So they would take the decisions about what the association should be doing in terms of work to the building. The work would be planned by way of an annual budget and service charge type of approach. So rather than, as in some tenements at the moment, work just being done kind of ad hoc, as and when the need arose, or maybe just the factor kind of taking forward work depending on the limitations of the contract that was in place. Instead, every year owners would kind of get together and think about what work is required in the following year, set a budget for carrying out that work, and then pay their contributions to that work by way of a kind of service charge, so a regular payment, instalment payment towards their share of the costs for that year. And ultimately that all this would be run through a manager. So the owners association is a person in its own right, but it still needs a human being to actually do things for it, like sign forms or go into the bank and open the bank account or whatever it is. So the owners association would need a manager who would be the kind of centre point for acting on behalf of the association. So this was the idea that the working group had in mind or recommended, and when they put that recommendation forward to the Scottish Government, it was accepted. But both the government and the working group had accepted that implementing a recommendation like that is, legislatively speaking, quite complicated, not least because a legislation of that kind is going to cut across the title conditions that are already in the titles of flat owners all across Scotland. So as I guess most people on the call will know, if you own a tenement flat in Scotland, the first place you need to look to find out what the rules are about maintenance in your building is in your own property title, where there may be conditions setting out saying who's responsible for what and how work can be carried out. So implementing a piece of legislation that would impact on those conditions is quite complicated and might have implications implications for the property rights of owners, not least in terms of Article 1 of the first protocol to the European Convention on Human Rights, which is this kind of human right to peaceful enjoyment of possessions. So because of all those complications, the government asked us at the Scottish Law Commission to look at the project to try to work through all those legislative challenges, and that's what this discussion paper basically is. So the discussion paper sets out our preliminary proposals for what a legislative scheme to implement owners associations will need to look like. As I say, this is a consultation document. The consultation on it is open until the 1st of August, and this is the second plug now for consultation responses. No doubt there will be more, but please do put in a response by the 1st of August if you've got views on things or if you're able to find the time for it. Okay, so that's the background to the project. I just also want to say a couple of words about the broader policy context in which this project is taking place. Again, some people on the call will be familiar with this, other people maybe less so. The broader policy here is that there's a wider programme of housing legislation and regulation that is being put together or is coming down the line from the Scottish Government. Broadly, the picture is that there is going to be increased regulation of home ownership in the coming years. So at the moment, if you are a private owner occupier, so if you just own your own house and you live in it, unless you're trying to make changes to your house in some way, extend it or make alterations, generally you're not going to have any engagement with the state around what you do with your house. That you're just kind of left to sort of get on with it. So if you want to just let your house just fall down around your ears, then unless it's causing some sort of public nuisance or it's causing danger to somebody or something like that, then it's up to you. You know, if you want to live in a poorly maintained, drafty, damp house, then it's really sort of up to you. But that is going to start changing in coming years. So the Scottish Government research has showed that housing in Scotland is in decline. That's all housing, not just tenements. I mean, our project is focused on tenements, but actually all of the Scottish housing stock is in a declining condition. And that is a problem in a country where we are currently experiencing housing shortages. So there's a lot of time spent in the sort of public debate at the moment about how we can maybe build more new houses. But of course, we also have to look after the houses that we've already got, or else the housing shortage problem is going to become worse. So there's a kind of public interest in making sure that we look after our housing properly. There's also kind of connected concerns related to both fuel poverty and the climate emergency. So the issue here is that a lot of our housing in Scotland is maybe not that well insulated, not that energy efficient, but we generate a lot of climate emissions in Scotland through heating our homes. That's a big chunk of where our climate emissions come from. So if we're going to reduce our overall climate emissions to reach the net zero target, then one of the ways that we're going to have to do that is by improving the energy efficiency of our houses so we're not using so much energy in heating them, as well as finding, you know, more energy efficient heating sources and that sort of thing. So that should help to make sure that people are warmer in their homes in the winter, but also help to reduce the level of emissions overall. So these different kind of policy concerns are all coming together. The immediate kind of upshot of that is likely to be, first of all, there should be a piece of legislation coming through Parliament. Maybe it'll be introduced later this year, I don't know, on heat in buildings. So this is a piece of legislation that's going to set out new standards for the energy efficiency of buildings and also the types of heating system which you are allowed to use in buildings, all buildings in Scotland, which includes homes, including privately owned, kind of owner-occupied homes. So the Scottish Government consulted on that at the end of last year and the start of this year, and legislation with that on that score should be forthcoming, I think, in the next year or so. In addition to that, the Scottish Government have got a commitment to introducing a tenure-neutral housing standard. So at the moment in Scotland, if you're a landlord, so if you're a private landlord and you let out property, then you are subject to a particular set of standards about the condition that property has to be in before you're allowed to let it out. Similarly, for social housing, there's a set of standards that applies for social housing. But as I say, if you just live in your own house, if you're privately owned owner-occupier of a house, the standards that apply to you are very minimal. But the standards are all different. The idea that the Scottish Government has is that they're going to have a new housing standard that applies across the board to all housing, regardless of whether it's owner-occupied, rented, or anything else. And that housing standard will almost inevitably increase what is expected of owner-occupiers quite a bit by comparison to the situation at the moment. So again, that's supposed to be happening at some point during this Parliament. I don't really know what the timetable is for that one. But these are two big pieces of legislation which are going to increase the general regulation of housing, particularly owner-occupied housing in Scotland. Our project, or this idea of having owners associations, is really a kind of jigsaw piece or a puzzle piece that lies at the heart of some of these broader policy ambitions. Because if the government want to increase regulation of housing, then in the tenements context, that's quite difficult to do if you don't have some kind of central organising body there who can be subject to the duties. And that's particularly true for things like energy efficiency related standards, because if you're going to make a tenement energy efficient, you really need to make the whole building energy efficient. There's only so much you can do in the individual flats. So the introduction of owners associations sits kind of in the middle of this broader policy agenda and isn't just strictly about improving maintenance of tenements for its own sake, although it is also obviously important in that context. So it's maybe just useful to have that background if you're coming to this relatively fresh. This is why this is sort of considered to be so necessary. Okay, all that background being said, let me get into a bit more of what we are saying in the discussion paper about what should happen here. So for anyone who doesn't know, the basic framework of the current law of the tenement looks a bit like this. The key piece of legislation is the Tenement Scotland Act 2004. In the main body of that act, there are about 26 or 27 sections covering various issues, including it sets out some default rules on ownership of different parts of the tenement. So as I said before, if you want to know who owns what in your tenement, the first place that you look is your property title. But if your property title isn't clear about who owns what part, particularly maybe who owns the roof or who owns the external walls, things like that, the Tenement Scotland Act sets out default rules which will apply to answer that question if it's not clear from the property titles. So you get that in the main body of the 2004 Act. The 2004 Act gives tenement flat owners the right to apply to court for certain disputes that might arise. The Act places certain duties on owners re-maintenance. Actually, the duties on owners re-maintenance are quite limited. So the main duty re-maintenance at the moment is set out in Section 8 of the 2004 Act, which says that if you own a part of a tenement building, then you have a duty to maintain that property so that it continues to provide support and shelter to other parts of the building. So obviously, you know, if you don't maintain the top floor flat, then water is also going to flood into the flats below it. Or if you knock away a supporting wall in a lower flat, the higher flats will fall down or whatever. So you've got this duty to maintain so as to provide support and shelter. We ask a question in the discussion paper about whether actually that duty should be expanded a bit to also make clear that the obligation on owners is to maintain parts of the building which they own as necessary in the interests of health and safety. So at the moment, that isn't a duty that can be enforced on an owner by the other owners in the building. If there's not a support and shelter issue, then health and safety issues aren't really covered by the maintenance duty. And we think that's probably just doesn't really make much sense, to be honest. So we ask about whether that should be expanded a little bit in new legislation. So that's duties re-maintenance. There are other duties set out on tenement owners in the 2004 Act, like you have to have insurance for the tenement, you need to provide access through your flat if necessary for repairs to other parts of the tenement and so on. And there are some provisions in there about demolition and abandonment of the tenement. That's all in the main body of the Act. Then there's an important first schedule, like extra bit, appended bit to the Act, which contains the tenement management scheme. The tenement management scheme is the default set of rules that will apply to govern management and maintenance of common parts of the tenement or strategically important parts of the tenement, if, again, the property titles aren't clear. So usually if you're trying to figure out what you need to do to get repairs done to the roof, you look at your property titles first, but if the property titles don't give you the answers, then you look at the tenement management scheme, and that sets out default rules which will apply where the property titles are silent on the issue or where what they say is incomplete in some way. That's the framework of the current law. In our discussion paper, what we are proposing is not any kind of wholesale revision of what's in there. What we suggest is that there should be some new sections added into the main body of the Act, which set out certain mandatory new duties or mandatory new conditions into tenement law. So some new mandatory aspects in the legislative scheme. I'll explain a little bit more about those in a minute. So there'll be some mandatory bits, which will be in the main body of the Act. Separately, we also suggest that the new legislation should repeal the tenement management scheme, to just get rid of the tenement management scheme, and then replace that with a new scheme, which we're calling the Owners Association scheme, which again will be a default scheme of rules that set out how management of maintenance is to operate where the property titles aren't clear. So we've got one mandatory bit, or one kind of strand of mandatory provisions, and then a separate kind of strand of default provisions in this owners association scheme. So let me talk you through the mandatory elements first, the mandatory elements that we suggest should be incorporated within the new legislation. So first of all, you're going to need a provision in the 2004 Act which creates an owners association for every tenement. So this will happen by way of legislative provision. The Act will say if there is a tenement, then there is an owners association connected to that tenement. So there's no question here of conveyancing being needed or companies registration being needed. Just if there is a tenement, then there is an owners association, and that will happen by virtue of the statute. On the same kind of lines, the statute will provide that if you are an owner of a flat in a tenement, you are a member of the owners association for that tenement. So again, it's just happening automatically. If you buy a flat, once you're an owner, you're a member, and if you sell your flat, you're no longer an owner, so you cease to be a member of the owners association, and that's all happening kind of automatically by virtue of the statute. That's the kind of key mandatory provisions. In addition, though, we think there need to be some mandatory duties on the owners association to make sure that it actually functions on some kind of basic level. So it's all very well to say in the legislation, oh, now there's an owners association, but if nobody is engaging with it, you know, if the owners just ignore the fact that that is the case in law, then you're not really moving the position on any from where we are at the moment. So we think there need to be some mandatory duties on the owners association just to make sure that it is operational at a kind of minimum level. So mandatory duties which will be enforceable by way of a scheme which I'll describe in a second. Okay, so the mandatory duties. First of all, there should be a mandatory duty, we suggest, on the owners association to appoint a manager. So I said earlier, you need a manager, you need a human being who can actually act on behalf of the owners association. And if there is no manager, it's really impossible to see how the owners association can function at all. So we think there will always need to be a manager appointed. In the discussion paper, we consult on who should be eligible to act as the manager, or if there should be sort of restrictions or qualifications on who can act as the manager of an owners association. But essentially what we kind of imagine here is that the owners association manager will either be the owner of one of the flats in the tenement who maybe wants to take on this role, or alternatively, and perhaps most likely in most cases, it will be a professional factor or a professional property management company. So it'll be up to the owners if if one of them is willing to do it, or if they're going to employ a factor or some kind of property manager to do it. But we think there needs to be a manager. And what we suggest in the discussion paper is that a manager should have to be appointed within 6 months of that position becoming vacant. So basically, when the legislation is introduced, then owners will have 6 months to appoint a manager to their owners association. And if after that the position becomes vacant because the manager resigns or leaves or dies or whatever, then they'll have 6 months from that point onwards to appoint another manager. So that's the first mandatory duty on the owners association, is to have a manager. We suggest there should be a mandatory duty on the owners association to have an annual meeting. So that's once a year there has to be a meeting of all the members of the owners association, to kind of discuss and plan maintenance for the coming year. Most importantly, at the annual meeting, members would be expected to vote on the annual budget. So we suggest there should be a mandatory duty to have an annual budget approved for the owners association. Now, as I say, the hope would be generally that would be getting approved at the annual meeting. But what we also suggest in the discussion paper is that if there's just sort of apathy amongst the owners, if you can't get anybody together to vote, then the manager should have the power to go to court and ask the court to approve an annual budget for the owners association. What that annual budget will contain in this instance, where the manager's having to go to court, what that annual budget will contain is any work that is required to make sure owners are complying with that duty in Section 8 to maintain the property so as to continue to provide support and shelter. So it's just a sort of minimum maintenance budget, if you like, to make sure that basic statutory duty is being complied with. So if members won't take an interest, won't do anything else, at least there can be that minimal maintenance there that can be achieved by the manager seeking court approval for the budget, and then owners will be charged, for the cost of that works in the usual way as if they had voted in favour of it. So those are the main three mandatory duties. If you've got a manager who's at least able to get an annual budget through with the involvement of the court if necessary, and then to raise debt enforcement proceedings against owners to pay their share if necessary. At least that can keep the owners association functioning to some sort of basic level. And the hope is that, you know, once owners sort of see that these mandatory duties are in place, they kind of might get on board a bit, even if they're initially a bit reluctant. I should say we also suggest one other kind of more minor mandatory duty, which is if any registration requirement is imposed on owners associations, it should be mandatory for them to comply with that. This is a kind of one-off thing that we had in mind, which is just about making sure that it's easy to find out which flats are in a tenement. So at the moment, like obviously if you stand outside the tenement and look at it, you can sort of see what flats you think are in it. But if you're like a trades person dealing with an owners association, there is no easy way to just get a list of what the flats in the tenement are. So what the land register title numbers of the flats are, or the postal addresses of the flats are. That's not, you can kind of work that information out from the land register, but it's not an easy thing to do. So we think there should just be a requirement just to register somewhere, probably on the land register, a list of what property titles are comprised in any tenement, so that everybody can be clear what the owners association actually represents. And we ask a question about that too. Okay, so these are the mandatory duties on the Owners Association, which we think are required to make sure that it functions at a basic level. I said that those duties will need to be enforceable. The way that we envisage the compliance with the mandatory duties being enforced is by giving the power to the court to appoint a remedial manager to the Owners Association if the members don't get together to do it voluntarily. So what we envisage here is if you've got an owners association where maybe you've got one owner of a flat in the tenement trying to get his neighbours to get involved with having a vote, but nobody will do it. Instead, that person could go to the court and say, will you please appoint me the manager? I can't get them to vote to appoint me as the manager, but the court appoint me as a manager? And if the court appoints that person as the manager, they will have all the usual powers that the manager has, including the power to call the annual meeting or to seek court approval for an annual budget. The purpose of the remedial manager should be to try to get the Owners Association into a kind of non-remedial management situation. You know, ideally the remedial manager will get the owners to a place where they will actually voluntarily choose to appoint a manager. But if that's not happening, then the court-appointed manager, the remedial manager, can be there just to keep things ticking over at a basic level. So who can apply to court for appointment of a remedial manager? I mentioned there that you know, an owner of a flat in a tenement might want to do it. But what we suggest in the discussion paper is that anybody with an interest in the Owners Association should have the power to go to court and ask for a manager to be appointed. So owners of flats in the tenement are the obvious people, but a tenant of a flat might want a manager to be appointed to make the Owners Association camp working. Or maybe a neighbouring Owners Association might want to make their neighbours' Owners Association start working if they're trying to organise works across several blocks of tenements rather than just one. Maybe a sort of, if it's a culturally significant tenement, a nice heritage building, then maybe a cultural heritage organisation might be concerned to make sure the tenement is maintained. So anyone with an interest in the operation of an owners association should be able to apply. And the idea is that that person will turn up to court and say, look, I am willing to act as the manager, you know, if it's an owner of a flat in the tenement, or else they will have approached a commercial property manager in advance who is willing to act as the manager within that tenement. So they'll be turning up to court to say, okay, I've had conversations with Joe Bloggs and they are willing to act as the remedial manager, so will the court appoint them? That's the basic idea of the remedial management scheme. Now, there is obviously a problem here in that it may not be possible to find somebody who is willing to act as the remedial manager. So owners might not be willing to take it on themselves, and they might not be able to find a commercial property factor who's willing to do it. What we suggest, or what we ask about in the discussion paper, is the idea that the local authority should have to act as the remedial manager of last resort in this situation. So essentially, if nobody else can do it, then the local authority will have to do it. Now, I've had a lot of conversations with local authority colleagues and housing association colleagues over the course of putting this discussion paper together. We absolutely recognise that the thought of having this put on their plate, along with all the other things that are already put on their plate, is not in any way an appealing prospect. We say in the discussion paper, and we will continue to say throughout this project, that there is absolutely no point in doing this unless it is resourced properly. So if the idea is that local authorities will have to take on this role, there needs to be money available to them to actually perform this role. So, but taking all those caveats into account, we just couldn't think of any other way to provide a kind of backstop for this system. Like, ultimately, the buck needs to stop somewhere, and it needs to stop with a state or a public body, and the local authority is the obvious body to do it, given that they already have this housing remit. There isn't really anywhere else to look. Like, you can't really have police coming around chapping people's door because they're not going to their annual meetings. So there just wasn't really anywhere to look. So I recognise that housing colleagues will probably not be excited to see that we have suggested this, but we just didn't really think there was anywhere else to go. I should emphasise that the person who's acting as the remedial manager, including the local authority if it's them, can charge for these services. So it's not something that you would be doing for free. It may, of course, be difficult to actually get the money out of owners, but it's not a kind of a voluntary service. But nevertheless, that doesn't change the fact there will be upfront resource implications. And we have emphasised in the paper that should be taken into account. Okay, so that's the mandatory elements of the new scheme that we recommend. The other aspects of the scheme will be default elements. So by default elements, I mean that these will be things which owners can agree otherwise about in their title conditions. So you still be looking first at your title conditions to see what the rules should be around maintenance. But if the title conditions aren't clear, then the new Owners Association scheme will tell you what rules should apply. So this Owners Association scheme will replace the tenement management scheme under what we suggest in the DP. Why have we not suggested just a mandatory scheme across the board? We did kind of look at that, about whether we could just have one set of rules that just applies to all tenements. So forget this, people can change things up in their title conditions, just everybody has to have the same rules. But there are a couple of difficulties with it, one of which is more sort of principled and one of which is more sort of pragmatic. So from the principle perspective, it's quite difficult to say that, bearing in mind the history and the traditional situation where everybody has a completely individual approach to the way that maintenance is managed within their own title conditions, to suddenly say all of that has been swept away and there's just one set of mandatory rules would be quite an interference with people's property rights, and really kind of goes against the grain of property law in Scotland, where people are generally given that kind of freedom to choose. So in principle, we're not sure that doing that could really stand up to the human rights arguments against it. But there's also a more pragmatic difficulty, which is just how do you come up with one system of rules that's going to work in all tenements in Scotland? Like, there's so many different types of tenements, different numbers of flats constructed in different ways, kind of lived in different ways. To come up with one set of rules that could really make sense for all tenements would need to have so many exceptions and caveats and, if this happens, then that happens type stuff in it, that it would be, just completely inaccessible, which is supposed to be the opposite of what we're doing here. So we just didn't think it would really work. But we do recognise that this kind of very individualistic approach to tenement management creates difficulties in practice because people find it so difficult to understand what the rules are in their own tenement. To help with that, what we are suggesting that maybe there needs to be more standardisation around the drafting of title conditions in future. So not the content of them, but the drafting of them. So what we are suggesting here is, what we envisage is that the Owners Association scheme will look as a document, will look written down on paper, a bit like the tenement management scheme looks at the moment. So it'll be sort of a set of rules where rule 1 will be, what powers does the Owners Association have? And then there'll be kind of a list. And then rule 2 will be, how do you call a general meeting? And then there'll be, rules under that. And then rule 3 will be, how do you vote at a meeting, and so on. What we are suggesting is that in future, if title conditions are being connected in relation to a tenement, they also have to be set out in that same form. So effectively, the whole of the Owners Association scheme will be reproduced in your property titles, but just with appropriate modifications. So the Owners Association scheme in legislation might say, oh, you need to give 14 days notice of a meeting, but in that tenement, people might have said, oh no, we need more notice than that, we need 28 days. That change will be made in the wording of the Owners Association scheme as it appears in the property titles. But it should mean that you can see the whole scheme that applies to your tenement just in your property titles, rather than doing what you have to do at the moment, which is look at your property title, look at the Act, try and figure out how or if they overlap, and which rule should apply in any particular case. So that might help to make it clearer. So we consult in the paper on the idea that that should be a requirement for any new conditions created after the Owners Association legislation is introduced. But we also ask about whether that should become a requirement for existing title conditions. So we're saying that in tenements which currently exist, which currently have title conditions that regulate maintenance, owners of those tenement flats should have to rewrite their title conditions in compliance with this new standardised form. And if they don't do it within a specified time period, their title conditions will just cease to apply. Now, obviously, that's quite a big exercise. So we're talking there about, a very long period of time for compliance, maybe about 40 years or something like that. But if after that period has passed, no new deed of conditions in the standardised form has been registered, then the title conditions will just cease to apply. And the Owners Association scheme in total will regulate what happens in that particular tenement. So that might help with making the rules a bit more accessible for individual people. And we consult on that in the discussion paper. Okay, so what I need to talk a little bit more about the details of the Owners Association scheme itself. The discussion paper looks at what the Owners Association should be like. So the working group said that the Owners Association should be a legal entity which has its own legal personality. We had a look in the discussion paper about whether we could use an existing type of legal person for that. Could the Owners Association be set up as a company, for example, or as a limited liability partnership, something like that? But ultimately, we concluded that the types of legal person which already exist in Scotland tend to exist for specific purposes, usually commercial profit-making purposes, or else they're charitable organisations, none of which mapped on very easily to the idea of what an owners association is supposed to be. So ultimately what we have suggested in the discussion paper is that the owners association should be a bespoke, a new type of legal person that only exists for the purpose of being the owners association. So we consult on that on the DP. Again, in the DP, we consult on who should be the members of the Owners Association. The idea there is obviously that the owners are the members, but there has been some discussion about whether residents in the building who are not owners should have some sort of say. So maybe tenants, for example, who might be more directly affected by poor maintenance or by maintenance work, should they have a say? Our view on this is probably that ultimately you can't have tenants or other residents having a vote because they don't have to pay for the work that ultimately will be undertaken. So it's difficult to give people that kind of control when they don't also have the responsibility to pay for it. But there may be other ways that tenants could sort of have a voice, albeit not a vote, in the Owners Association. And we talk about that to an extent in the discussion paper. We also look in the discussion paper at what the Owners Association should be responsible for in the tenement. So the idea here is that the Owners Association should be responsible for what is called under the current law scheme property. So scheme property is basically, to talk loosely, the kind of strategically important parts of the tenement building. So the roof, the foundation, the external walls, these sorts of things where it matters to everybody whether they're properly maintained or not. In the discussion paper, we look at whether that definition, as it is under the 2004 Act, remains appropriate, or maybe if some tweaks are required. So we ask about that. And then we also look at some general administrative matters, including the suggestion that the manager of the Owners Association should be under a duty to maintain a list of the names and contact details of the members of the Owners Association. So owners of the flats will have a duty to keep the manager up to date if their contact details change, and then the manager will be under a duty to make sure he's keeping that up to date, or to get in touch with people if he's not, if he's not sure the contact details remain correct. That is a real pain at the moment. I know for people sometimes just trying to find out who their owners are, or to try to get in touch with other owners in the building. So that should help a bit. And then the manager would be able to disclose that information to other owners where it's necessary in connection with management of the tenement. So that's some of the basic stuff around the Owners Association. And then looking onto the Owners Association scheme itself, we have various chapters on this in the discussion paper looking at the detail. So we've got a chapter that asks about the function and powers of the Owners Association. So I said before that the Owners Association will be a legal person. So, as a sort of person in its own right that can do certain things like enter contracts. But we recognise lots of different legal persons in law, and they don't all have the same powers. So a company is a legal person, but a company can't adopt a child, or like a human being is obviously a legal person, but a human being can't be kind of issuing shares in themselves to raise some money. So not every legal person can do the same thing. So there needs to be something in the law that says, well, what can the Owners Association do? What powers does the Owners Association have? What we suggest here is that a sort of basic rule that the Owners Association should be able to do anything necessary in connection with its function of managing the maintenance of the tenement. But we also ask whether there should be some specific restrictions. So we suggest that the Owners Association should not be able to operate as a profit-making enterprise. If you want to run a profit-making enterprise, that really needs to be done through the company law, where you're subject to the regulation that companies are restricted to, and allowing owners associations to do that when they're not subject to all the same requirements seems like it would be very unfair. We also ask about whether the Owners Association should be able to own property outside of the tenement. Again, there doesn't really seem any reason why the Owners Association would need to do that. But the chapter looks at those sorts of questions. So what powers should the Owners Association have? Then there's a chapter that looks at decision making by members of the Owners Association. So the Owners Association has these powers, but it can't actually use any of them unless the members decide that that's what it should be doing. In the same way that a company has powers, but it's the shareholders who decide how the powers are exercised, at least to a certain extent. So we look at how the members can make those decisions to exercise the powers. So that chapter looks at, first of all, what the voting threshold should be for exercising different powers. At the moment, generally, a simple majority is required for maintenance of the tenement building, but you will need a unanimous consent if you want to carry out improvements to the building. That's the kind of basic division. In the discussion paper, we look at whether maybe we should be moving to a kind of qualified majority rather than unanimity for these other decisions. So maybe you'd have a special majority of something like 75% or 80% of votes rather than requiring 100% of votes for improvements. So we ask about that in the discussion paper. And then we also look more functionally at how decisions might be taken. So how does a meeting get called? Can you take decisions outside of meetings by having a kind of a WhatsApp group or an email chat or whatever? So just look at these more practical questions about how members can communicate with each other to make decisions to exercise the powers of the OA. So that's the decision-making chapter. We have a chapter that looks at the role of the manager. So what is the manager empowered to do and what responsibilities does the manager have? So the idea is that the manager will be doing the day-to-day work of the Owners Association. The owners will make decisions that are maybe kind of bigger, more strategic decisions and delegate powers to the manager to just kind of carry those out day to day. So it's not like every time the manager wants to make a phone call, there has to be a decision taken by all the members about that specific phone call. You know, so those smaller powers would be delegated to the manager to be exercised within the bigger decisions which had been made by the members. So we talk about what the manager's role should be and also talk about certain responsibilities we think should be placed on the manager, such as the responsibility to call the annual meeting, the responsibility to keep that contact list up to date, and so on. So that's in that chapter. We also have a look there at how the role of the manager interacts with the property factors regulations. So the Property Factors Scotland Act 2011, how that role will interact with the provisions of that scheme. That's also in that chapter. Then we have a chapter that looks at liability for costs and the annual budgeting process. So we know there needs to be an annual budget, but what is that annual budget supposed to look like? How much detail needs to be in it, for example? That's covered in that chapter. And we also look at how the costs of work are to be spread out amongst the different owners in the building. What we suggest there just basically looks the same as the TMS. In fact, that's true for quite a lot of this stuff. Like the stuff in the decision-making chapter about how you call a meeting or how members can vote, that also looks quite a lot like the TMS. Like generally speaking, we have tried to just maintain quite a bit of consistency with the existing law wherever that's possible, because it just makes it easier for people, but it also makes it less of an interference with people's rights if you're not changing things just kind of essentially for the sake of it. So a lot of the stuff in that chapter looks very similar to the TMS, albeit that the setting of the budget part of it is new. And then finally, we have a look at enforcement. So how can owners or the manager enforce their obligations against one another? One of the things that we ask about in that chapter is whether there should be a change of court for hearing disputes amongst tenement owners. So at the moment, if you're a tenement owner, a flat owner that's got a dispute with one of your neighbours, then you deal with that by way of summary application to the Sheriff Court. But we ask in the paper about whether it would make more sense in future for these disputes to be heard by the Housing and Property Chamber of the First Tier Tribunal. So the tribunal is a kind of less formal kind of place to resolve disputes. It's not as expensive to go to. It doesn't have the same formal writing requirements. And the tribunal panel can be a lot more interventionist in trying to get people to a solution than a sheriff court, a sheriff court judge would be able to be. So we suggest that maybe the first tier tribunal would be a better place in future for disputes rather than the sheriff court. We ask about that. As I already mentioned, we suggest that the manager of the Owners Association should have the power to ask the court for approval of an annual maintenance budget to make sure the OA can keep functioning. Another thing that we ask about is in terms of debt enforcement, if you've got an owner who is not paying their share of the costs of the work, then should there be the power for the Owners Association to make use of what we're calling tenement restricted land attachment? What that is the power for the Owners Association to put a charge, so a kind of a security or a mortgage against the title of the flat, the owner of which is not paying up their share. So it would appear on the property title against that flat. And if the flat is sold, then the owners association would be able to recoup all the debt that is owed to it from the proceeds of that sale before the seller could take any of the proceeds away with them. So we suggest maybe that should be introduced for tenements. We think if the property in question is a kind of commercial, an investment property, so not the person's home, not the debtor's home, but maybe the debtor is a company that lets out flats or something like that. If it's not the debtor's home, then we also ask about whether the tenement restricted land attachment should give the owners association the power ultimately to sell the flat, to forcibly sell the flat against the wishes of the owner and recoup the funds that way. That's something which certainly I don't think we would be able to introduce in a human rights compliant way if the flat is the owner's home. Forcing somebody to become sort of homeless as a result of debt is not likely to pass muster in a human rights sense. But if it's not the person's home, then maybe there is a possibility that you could compel a sale in that context for the money to be produced to cover the debts. So we ask about that. I should say this land attachment, this idea of land attachment, this isn't something that we came up with. This is something that already kind of exists in the sense that it's on the statute book, although it's not currently available to use in Scotland. And the government is, and not just for tenements, I should say, just a general power of debt enforcement against somebody's buildings or property. The Scottish Government is doing some other work on that at the moment. There is a general review going on at the moment which involves land attachment, so it may be that there are other legal developments happening there which might, well, we'll keep an eye on that as the project progresses, depending on whether consultees are supportive of this idea of tenement restricted land attachment that we suggest in the discussion paper. Okay, so one final point to make is about applying this new legislative framework. So the question here is, should the Owners Association regime apply to every tenement in Scotland, or are there some tenements which should be exempted? So when the working group made their recommendations, they sort of recognised that maybe, if you've got a small tenement that's maybe only 2 flats, then do you really need an owners association? And, are you really going to have an annual meeting and an annual budget and all that? It maybe seems a bit kind of heavy-handed if you've only got 2 flats in a tenement or that sort of thing. So when we started looking at this, we realised that there were maybe a couple of problems with just wholesale disapplying the regime from certain types of tenement. So one problem is that people might want to take advantage of the benefits of the owners association even if they don't strictly need it. So even if you're only 2 flats in a tenement, you still might want to be able to open a bank account as the owners association, or borrow money or get grants as the owners association, rather than one owner kind of having to do it on behalf of the other, or both people having to be involved all the time. So there maybe would be some benefits that could be lost to owners if we disapply the regime entirely from certain tenement types. But the bigger problem really is if there are no owners associations for certain tenement types, then this broader regulatory programme that is envisaged by government is going to be difficult to roll out. If we're talking about regulatory duties that apply to tenements as a whole, like, as I say, maybe around energy efficiency of the building, and there's no owners association, then that is going to be difficult for the government to impose that duty in any kind of effective way. In addition to which, just from the perspective of the legislation itself, if some tenements don't have owners associations, then for those tenements, you would need to keep the tenement management scheme on the statute book, because that would still be the default scheme which would apply to those tenements. Whereas for most tenements which did have an owners association, the OAS would apply. That also sort of looked like it's just making the law actually much more complicated rather than less complicated, which is maybe not ideal either. So in the end, what we've come up with is the idea that all tenements will have an owners association, but the mandatory duties on owners associations will be disapplied for tenements where that doesn't make any sense. So you will have an owners association if you are, for example, a small tenement. You will have an owners association, but the duty to have an annual meeting will be suspended, and the duty to have an annual budget will be suspended, and so on. So the owners association will exist, and the OAS will still apply as a set of default rules if your title conditions aren't clear on stuff, but those mandatory duties will not apply and cannot be enforced. So we thought that might work for small tenements. We ask about what should count as a small tenement in the discussion paper. So maybe 2 flats, 3 flats. We ask a question about that. We also think this idea of having an owners association but suspending the duties might work for tenements where all the flats are in single ownership. So if you've got a block of flats that's all owned by a housing association, for example, suggesting that the housing association should get together with itself to have an annual meeting doesn't make any sense. But you could state still has the owners association, but the duties don't apply. We thought it might also work for tenements which are managed as part of a wider development. So this is quite common in more recently constructed tenements which have been built as part of a bigger housing development. Sorry, I've just realised I'm really running over time. That they would have an owners association, but so long as there's a manager for the development, then that would count. And only tenements subject to a DMS would be totally excluded from the owners association scheme, since they already have a separate owners association. Okay, questions. Sorry.